It's Mike Franklin, the property tax guy, and today I'm going to do an update on the video that I did on regarding the town of New Haven incident regarding the arrest of Michelle Allen for obstruction of a governmental administration for asking in a public hearing if they were going to be providing minutes for their executive session. Well, they could have just said no, but instead they called the sheriff's department. And so I have an update on the charges. So there was original charges that included obstruction of governmental administration and criminal trespass. Later, they added disorderly conduct. And so, why would they add disorderly conduct? Well, that was probably the DA's idea because it's a violation. It's not a misdemeanor, and the burden to prove that is fairly easy. And actually, if it's charged alone, you're not entitled to a jury trial, and nor are you entitled to a public defender. So I think the mistake the district attorney made is he should have just charged disorderly conduct and forgiven all the other things, because it put him in a bad position. Because if he charges those things, the disorderly conduct charge can be addressed at the same time. So I think he made a mistake there because no lawyer would want to get involved in it for a disorderly conduct charge, and there's no jury and there's no public defender, and so she would have been defending herself, and likely a judge would side with the district attorney on that one and the sheriff, because one of the reasons for doing that is that if you are convicted of any charge, it pretty much precludes you from a civil lawsuit. And so the DA kind of screwed up by getting the whole thing dismissed, because if he could have convicted her on any charge, she'd be in a bad position for her civil case. But now she's in a great position for her civil case, because she is entitled to a jury, and she can depose the sheriff, would be my guess, and she can depose the town supervisor, and she can depose that deputy Gregory. And I tell you, Deputy Gregory thinks that she can identify people when she's investigating them, and well, she's wrong about that. And she thinks she's a real tough guy, out there in the field with her gun and her badge, talking down to people, being porky, unprofessional. And out there, apparently she can get away with that because apparently the sheriff's good with it. But when she's in court, it doesn't work that way. And it would be hilarious to depose that woman, because she wouldn't have the right answers to the questions, I can assure you. But what's interesting is that ultimately the final charges had nothing to do with what transpired in the original town meeting. The supervisor came up with some nonsense about Michelle barging into his office when he was talking to a newspaper reporter, and so apparently the charge was associated with that, and that had happened a month earlier. If to me, you just could call the cops, say, hey, a month ago somebody burst into my office and was mean to me. But apparently that's what the charge came from. And then the criminal trespass, to me, the criminal trespass, it was dependent upon getting a conviction for the obstruction of that meeting, because you can't trespass somebody from a public building unless they've committed a crime. If she's found not to have committed a crime, well, then there's obviously no trespass. And like I said, they charged her with, I think, second-degree trespass, I think. And it really, if anything, it could have been a simple trespass. And so they overcharged her on that one. And it's just hilarious. Let me see what else I've got here for you. Let's see. Yeah. So Deputy Gregory, uh, she's so busy talking about failure to ID that she never investigated the original charges. And then they're having this dialogue back and forth about obstruction of governmental administration. They provided paperwork for for these rules of decorum, which had nothing to do with the charges. And she's asking the deputy for the statute, and the deputy says, I don't keep a law book in my back pocket. Well, the thing is that you're the one making the charge, so you should know what that statute is if you're charging it. And it's pretty darn clear that she didn't know what the statute was. She didn't know that it required intent. And yeah, she's charging somebody with a statute that she doesn't know, and it's just hilarious. What else we have here? Yeah, at one point, Michelle Allen said that this is a waste of money, and the deputy says, "Well, all she had to do is provide your ID. Yeah, all she has to do is give up her constitutional rights, and she'll be all set." Bravo, deputy, bravo. Truer words were never said. What a waste of money! What a waste of taxpayer money. So then they got 5 deputies hanging around for this nonsense. They should have told her to move along. And then they go down to the jail, involve all the jailers and the liability associated with that, rides in cop cars, all that kind of stuff. Then they put her in leg irons and take her down to the arraignment. So you're dealing with the deputies, the jailers, the district attorney, his people, the public defender, his assistant, 4 different judges, their secretaries, their law clerks, and then ultimately, there's going to be a civil suit. So the county's going to have to pay their attorneys to defend the civil suit. So truer words were never said. What a waste of money! It's just a complete abuse of discretion. It's hilarious. But let's see what else we have here. And you know what? This deputy is so adamant that she can ask for ID, or she can ask for ID anytime she wants. That's not a problem. But when she demands, when she demands identification under threat of arrest, then and she's so adamant about it, it's pretty apparent that it's a patterning practice issue with the sheriff's department. So they're training these people to violate people's constitutional rights, and that could be there could be a Monell claim for that. This would be a 1983 civil rights lawsuit against the county for systemically violating people's Fourth Amendment rights, and I think that there might be something there. And to get that sheriff to stop doing what it is that they're doing, what is it going to cost? What is somebody going to have to sue them for in order to get them to stop? And I'm thinking a couple $1 million. What else we have here? The deputy says, unfortunately, that's not the way the law works. Boy. So, with this behavior of the sheriff and the behavior of the town supervisor, Barney, the convicted felon, Barney has an excuse for his behavior. He's a criminal, and he doesn't know any better. He doesn't know right from wrong. That's his excuse. He's a criminal. What is the sheriff's excuse for their behaviors, for their unprofessionalism, for their lack of knowledge of the law? What's their excuse? Well, I'll tell you what their excuse is that they're not accountable to anyone, and something needs to be done to make them accountable, financially and legally. And like I said, Deputy Gregory is a real tough guy out there with her badge and her gun. Walking up on her. Oh, you need to provide your ID, and she walks up on her. It's hilarious. But in a deposition, these cops don't tend to be so tough. They're these little meek little people in depositions. And in the street they're tough guys. They got their gun and everything. But in a deposition, they're little back in their chair and they're like, oh, it's hilarious. So like I said, the DA's mistake was, and the sheriff's mistake was in charging him for all these things that didn't apply. They should read these statutes that they're charging people on, because, if they just took a second to read the statute, they'd know that it doesn't apply. So, if they wanted to jerk her chain, which is obviously what they were doing, they're trying to teach her a lesson. That's why they put her in jail overnight. That's why they put her in leg irons. They want to teach her a lesson. And so if they really wanted to teach her a lesson, they should have said, the heck with the obstruction of governmental administration. Forget the criminal trespass. They should have charged her with disorderly conduct, because it would be easy to convict her of that, and she wouldn't be entitled to a public defender, and she wouldn't want to pay a lawyer for something so petty, because all it is a fine. And it's up to 15 days in jail. I'd like to see a judge put her in jail for 15 days for this nonsense. I'd like to see who the judge would be that would do that. So maybe they could put her in jail for 15 days, and that would quash her ability to file a civil suit, because no attorney would get involved over a disorderly. It's just not enough there. But yeah, the sheriff just has no problem pissing away the taxpayers' money with this utter nonsense. He needs to train his people properly, and it needs to start now. I'm gonna talk to the county legislature one more time, and try to educate them on what the sheriff is doing. They might not even know. They might not even know that they can't be identifying people in this manner. You know what? And like I said, I went through the video, and that Deputy Gregory requested ID more than 20 times in a matter of 10 minutes. And I calculated it was about 10 times that she demanded it, and basically under threat of arrest. And it's unlawful. Now, in the end, it doesn't make any difference. Yes, she can detain her for the investigation, but get to it. Do your investigation, because you have a limited amount of time in which to detain her to do your investigation. Well, she never bothered with the investigation. She just arrested her. And but you can't charge somebody with failure to ID prior to arrest. And that's exactly what it is that she was. That's exactly what she was doing. So again, she can be detained for investigation, but in order to require by law her ID, she has to be arrested. Well, ultimately, she was arrested, and then she provided her ID. So the whole conversation was pointless to begin with. But to me, it's important, because these deputies are out intimidating the public into giving up they're using their badge and their gun to intimidate the public into giving up their constitutional rights. And it's not proper. They can ask all they want, but they cannot demand, under the color of law, identification unless they're being charged. And I think that's been well established. And maybe I'll do a video just on that. But the Oswego newspapers did a story where they reviewed that point, and they contacted some what they considered to be legal experts, and those legal experts agree or are consistent. What they said is consistent with what it is that I'm telling you. But again, Barney has an excuse. He's a criminal. What's the sheriff's excuse? He needs to get his act together. This is Mike Franklin, the property tax guy.